Great, and we're live.
Hey Nick, how you doing?
I'm fine, thanks, and you, Bruno?
I'm good. You're becoming quite efficient in actually logging onto someone's profile and bringing us online.
I'm getting there, but I will say I won't do it without. I don't do it without help from people in the office. It's that one secret that you never want to tell your clients. That in all honesty, if you didn't have your secretaries and your PAs, nothing would
Oh yeah,
happen.
oh yeah. It's
Absolutely,
like gold. It's like gold. Sometimes more valuable than some of the attorneys that
a
work for us.
100%, a
Yeah,
100%.
it's good to see you again. Everyone's almost busy today. So Nick is joining us, and yeah, and we've got actually quite a few interesting things to chat about.
Yeah. So what we thought we'd discuss now is, for people sitting within the property industry, there's been a massive case that's just come out within the last month. It was a case from the Constitutional Court of South Africa, a very long-legged case, instituted already in 2009, and eventually a Constitutional Court judgment after a number of appeals was given last month. And it's a very interesting case. We're going to try not to bore our listeners with all of the legalese and the facts behind the case, but we thought we'd just have a discussion on what exactly the case was, what the ruling was from the Constitutional Court, and the implications on the landowners and property industry as a whole. So I think, Bruno, do you want to give just a quick breakdown of what exactly happened?
Yeah, cool. Awesome. So for the first part, maybe just trying to bring some context to the case. We're not going to go through the details, but our initial panic when we had first seen the High Court rulings and the SCA rulings was the court kind of supporting this notion that certain tenants almost have an absolute right to stay on the property. Unlawful occupiers have an absolute right to stay on the property in spite of the occupation being unlawful and in spite of the landlord or owner actually having full rights of ownership. And the way that they treated this was, unfortunately, because of the person's age and certain considerations. So everyone needs to remember, we've got certain legislation in South Africa that governs the way that evictions are handled. And I think that is the fundamental to this conversation that everyone needs to understand as a landlord, right? Why do these exist? These exist because we live in a society where homelessness is a problem. Poverty is a problem. So this was introduced in order to support the constitution of the country when it comes to everyone's rights to housing. However, this is not an absolute right. Housing is not, it needs to be balanced with rights, for example, of ownership and being able to own land, own property. So the Constitution enshrines the spirit of, everyone having these rights, and the legislation is about trying to find a balance between, two differing rights almost, and trying to find a better way of dealing with it. So the legislation came out and said, cool, guys, listen, as property owners, you're entitled to evict people, but the evictions have to be subjected to certain considerations. So if a person's been there for a really long period of time, you have to consider things like their age, how many kids are there, whether it's a woman-headed household, disability, a whole range of stuff. We're not even going to get into the ESTA conversation. So that's another piece of legislation. So we have PI and ESTA. I'm not touching on ESTA now because that deals with farmland, agricultural, and that sort of thing. So us in the residential realm, we focus predominantly with PI. So PI has these considerations. So with this case that we are now speaking about, our concern was that the High Court and the Supreme Court of Appeals interpretation or application of PI was concerning because this would open the door for courts to start refusing eviction orders being granted to proper owners where the occupants were unlawful simply because these considerations were to such a degree that the court felt that the order should not be granted at all. So this case was from the Constitutional Court. And in our hierarchy of courts, you've got Magistrates High Court, and then you've got your Supreme Court of Appeal. But the Constitutional Court does trump the Supreme Court of Appeal when it comes to constitutional matters. And this went to the Constitutional Court. It was a constitutional matter reflecting the rights of an owner of a property, constitutional rights, and the interpretation of PI. And the courts here, thankfully, for us as property practitioners and property owners, the courts did find that even though a landowner is expected to be patient, our laws aren't supposed to effectively expropriate land from an owner to the degree where a tenant can just stay indefinitely and a landowner must just, swallow that pill. There needs to be a balancing right, and the courts will consider a variety of things, including poverty and homelessness, but they'll consider many things. In this case, there's even the provision of alternative accommodation. But at the end of the day, the owner's rights do need to be considered, do need to be balanced, and the owner cannot be expected to give up everything just because. We all know quite well. So the previous case law that speaks about the owner not having to provide alternative accommodation. And I think this is where maybe we lead on to the second question that I have for you, which is, so this case did I wouldn't say prioritize, but it did give effect, or it did give a sounding board to owner rights where the previous courts did not consider it to the same degree. It did speak about ownership, having to be considered more. However, there is, it didn't say in an absolute way that as an owner, you are absolutely entitled to an eviction order if you're owner and the person's unlawful occupier, because our approach has always been, well, we're owner, we're entitled, but maybe the court will give them a longer period of time. They're just and equitable would be based on time. So maybe just go into that in a bit more detail, like what is justice and equity, or just an equitable eviction order? Does that mean the order can be refused? Is it about periods of time? What's your feelings on this case?
Yeah, so I think what's important and what the Constitutional Court had sort of commented on from the other courts that had dealt with this case before it got to the Constitutional Court was obviously what the courts need to look for an appropriate order for eviction in the circumstances. So specifically, when an eviction is being granted in our country and under our legislation, the first inquiry is always going to be an inquiry into the unlawful occupation of the occupants of the premises. Okay, if the tenant isn't in unlawful occupation, so they've got a right to be on the property. Say you've got a lease and the lease isn't cancelled, or they've got some other rights to the property. There are small, more complex rights that one might have to a particular property. In this case, they in fact dealt with something that's called a habitatio. Now, I don't want our viewers to get worried about the Latin there. All it means is a life right to occupy a premises, and there are certain laws and rules that revolve around a habitatio, how it's enforceable and when it can be enforced. But they touched on it. There's certain rights that one might have to a property to stay there, and in the event that right can be demonstrated, you will not get an order for eviction in the circumstances because they're a lawful occupier of the premises. But what the court has emphasized in this particular case is in circumstances where an occupant is found to be unlawful, then there's another inquiry that the court has to go into. And this is part of the reason that an eviction in South Africa has to go through a court. You'll know if you listen to some of our older podcasts, the tribunal specifically can't order an eviction of an unlawful occupier, and it's because there has to be some level of judicial oversight over all of the relevant factors in a case, so that the court can make the determination on what is just and equitable in the circumstances. All right, and PI specifically says all relevant circumstances. So everything might be relevant to this particular inquiry. It does set out some specific elements which should be addressed, but really the court's going to look at everything in the circumstances. Now, what is interesting about this Constitutional Court case is that the factors that were at play in this particular case were very extreme. The occupier in question had lived on the premises since she was 11 years old. She was at the time of the hearing in her 80s, so she had lived on the property for 70 plus years. Okay, so it's a very extreme circumstance. And obviously the court had to, as you say, do a balancing act between the owner of the property and the particular tenants in the circumstances and what their rights were. But what I did take from the case and what I did think was important was the court applied the judgments which it had already set out when it comes to eviction. So there was a groundbreaking case, which is the Blue Moonlight Properties case, many years ago. And in terms of the Blue Moonlight Properties case, the Constitutional Court also had held that an owner cannot be expected to provide free accommodation for a tenant indefinitely. All right. So, and in this case, they once again reiterate the position. And it's part of the reason that the court had sort of gone and said, well, the SCA didn't see this right, because the effect of the SCA judgment was that the tenant could indefinitely reside on the premises. Again, the court sits and says, well, we've got to balance this. You can't expect a private landowner to just to forego their property for the rest of another person's life or for an indefinite period. And so, from my interpretation of the particular case, look, the question of what is just and equitable in the circumstances, as I've said, that depends on all of the relevant factors of a particular case. And so the court has very particularly, or legislation at least, has very particularly left that open-ended. Okay, they've left it open-ended because depending on your particular case, I mean, you could have any number of relevant circumstances. No two cases are alike when it comes to eviction applications. And as much as the process might be the same, the facts behind those processes change constantly. And it's important for attorneys to keep abreast of, well, what is actually at play in this particular case, so that you've brought the right thing before the court and the court is kept abreast of all of the relevant information to make an order. But I did think that the interpretation of the Constitutional Court in this particular case was great, because they again confirmed the position that that an indefinite period is not acceptable for a private landowner to carry an unlawful occupier. So to your question, do I think that it might lead to judgments that where the court goes, well, you can't evict them from the premises? I would hope not. It does seem to me that the Constitutional Court in this particular case is confirming the position that was already set out in Blue Moonlight, to say, well, you can't just expect to keep a property forever, and just keep a tenant for forever. But the court then again goes into the inquiry of, but you have to find out what is just and equitable in the circumstances. And in this particular case, I mean, the eviction was eventually granted. The court took into account a number of factors, including the fact that the litigation proceedings took some 14 years to get through from institution all the way to the end, as well as a number of other factors. In this particular case, the landowner had tendered alternative property to the tenants. And I think it's very important that we mention again the very last remark of the court when it came to the alternative accommodation. They say specifically that it didn't create a precedent that the private landowner has an obligation to provide alternative accommodation in the circumstances. It happened to happen in this case. It was tendered, and it was still at the time of the Constitutional Court hearing tendered by the particular landowner. But the court goes on and says this isn't a precedent for that. In the circumstances, it is a factor which must be considered.
Sure.
So my personal interpretation, I don't think you would hope that Blue Moonlight Property, which is now being confirmed again in this particular case, you can't have a tenant just occupying a premises indefinitely. There's got to be some balancing, and the court specifically in this mentioned, you can't overbalance the rights of an unlawful occupier in the circumstances. You have to weigh that up against the rights of the particular owner. So we'd hope that we don't get an interpretation off the back of this that it definitely is allowed. But as the court says, you know, specifically in this case and the Blue Moonlight case, landlords might be expected to be patient. Depending on the circumstances, you might have to be a little bit patient. And that's an inquiry for the courts at the end of the day. What would be reasonable?
Sure. No, that's great, Nick. And I just wanted to add two things just before we wrap up. So first thing, just for the viewers, we have so this part of the conversation relates to this case. That is, like Nick mentioned, the circumstances behind it were quite extreme. So, you know, we mustn't interpret this now as being oh no, it's going to take me 14 years to do an eviction. It's two ends of extreme, right? We've had evictions in 3 weeks, which not even 3 weeks, like 3-4 weeks in these special circumstances where the courts back in the day used to function in a completely different way. And like I've had evictions take a number of years, right? The reality behind it is between these extremes, there's certain odds that stack up to, you know, the majority of the evictions taking place within a certain period of time. More often than not, when it comes to tenant evictions, so an eviction cannot take less than 14 days because of PI as an example. And obviously through court process, it just keeps adding on, right? You know, fastest eviction I think anyone's ever gotten is like 6 weeks, somewhere around there, unless you can actually get the guy out through letters and just serving the notice. But then it goes up, and you probably have a peak over here of in 3 months, you could probably get a tenant eviction. And then you start dealing with things like sales and execution, and you start seeing that it takes a little bit longer. And, you know, then the odds, then only the difficult cases remaining. So people need to remember most cases, 3 to 6 months, and then you start seeing like the harder cases. This was a very hard case because of like 70, the person lived there for 70 years. They were arguing that they had a right from a previous owner that couldn't be proven, etc., etc. So that's thing number one. Interesting thing number two, Nick was speaking about relevant circumstances. And there was something very specific that the court said that I find crucial because I've experienced this so many times. If what's not relevant is the tenant's desire as opposed to the tenant's needs and being rendered homeless. So a tenant that simply wants to live in an area because they want to maintain a certain lifestyle is very different from a tenant, you know, the court having to consider whether they're going to be rendered homeless and whether their life is going to be turned upside down. And I've had cases like this where people were living in very lonely areas and they didn't want to move to an area that was more suitable to their budget because they liked living in these security estates and stuff like that. And in this case, the court didn't think that this was a consideration that merited a lot of attention in her circumstances because she was going to move somewhere that was very similar. And her desire to stay in that specific house, you know, already carried no merit.
Yeah. 100%. Yeah.
Cool. Awesome. But thanks so much, Nick. Always fun.
Thanks.
Yeah.
Be good.
Yeah. We'll probably see you again next week.
I am seeing you again next week. I've already been told.
Nice. Cool.
Perfect.
Awesome. Have a good one, and yeah, chat soon.
Hundreds. Thanks, Bruno. Cheers.
Cheers.